Leader of the third party.
Thank you, Honourable Speaker. Please allow me to get my stuff composed here for 1 minute. I thank you again, and thank you to the Minister for bringing this bill forward, Bill 9, the Workmen's Compensation Amendment Act 2018, a bill which I clearly stand in strong support of, and with my colleagues in this House. As was mentioned by my colleague from Chilliwack, this bill updates the Workers' Compensation Act so that those working in eligible occupations, we'll come to that in a minute, who are exposed to one or more traumatic events over the course of their employment and are subsequently diagnosed with a mental disorder, we'll come to that as well in a second, they'll be presumed to have been will be presumed to have been caused by the nature of their work rather than having to prove that it was work-related. Now, this particular bill is targeting the eligible occupations, namely a correction officer, an emergency medical assistant, a firefighter, a police officer, a sheriff, or other as prescribed by regulation. Now, that's important, that or other as prescribed by regulation, and we'll come to that as well. The term, as I also mentioned in that introduction, the term mental disorders is actually a term that's being used to define, it's defined by the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders, and right now that's in its 5th edition. It's termed DSM-5, and that 5th edition was published in 2013 and is presently in the process of being updated. I'll start here, Honourable Speaker, because it's a very important interjection that I'd like to do right off the bat to highlight one particular difference between the present legislation and that legislation which was brought in by the member from Vancouver Hastings, the Minister, and I'm having a slight trouble with the title of the ministry. I do apologize. He brought in 2016 Bill M203, the Workmen Compensation Amendment Act 2016. It was a private member's bill. I sat in the legislature as the member then read in. We passed first reading, of course, wasn't brought for discussion. But why that's important is I've mentioned the prescribed the eligible occupations already, and if we refer to this previous bill and we look at the eligible occupations in that case, we see a number of differences. We see here that when we look at first responder, it means the following: an individual who is an emergency medical assistant licensed by the Emergency Medical Assistance Licensing Board, a full-time firefighter or part-time volunteer firefighter, an individual who appointed as a peace officer, police officer, a peace officer, a sheriff, or corrections officer. All of those are covered. But most importantly, Honourable Speaker, Section 5.2E of the private member's bill, brought in by the former member from Vancouver Hastings, says this: 5.2E, a 911 communications officer employed by any of the above organizations or by Emergency Communications for British Columbia, Inc. Now, Honourable Speaker, that's important because that one distinction is a difference between the private member's bill that clearly his party was supporting back in 2016, which does not appear here in Bill 9. It's specifically excluded. Now, I suspect that the Minister, through Lieutenant Governor Orders and Council, will prescribe this profession coming to the future. But I will be, as we move forward, Honourable Speaker, proposing a number of amendments to this bill, and one of those will be specifically to deal with 9/11 dispatchers for reasons and rationale I'll describe shortly. Honourable Speaker, only Quebec, Nunavut, Northwest Territories, Newfoundland and Labrador, British Columbia and the federal government, Canada, do not already have some form of presumptive language or legislation for mental health concerns, and in particular at the federal level, recognizing some of the concern that's with respect to our military coming home and the preponderance of PTSD and the unacceptable and sad rise in suicide amongst our military personnel, people who put their lives on the line for all of us. The federal government last year, and done by actually a British Columbian, the MP from Caribou, Prince George, Todd Doherty, he introduced a private member's bill. It's what's called Bill C-211, an act respecting a federal framework on post-traumatic stress disorder. And he was looking to create this federal framework to address PTSD in general. And right now, it's actually good news. I'm hoping it follows through. It's passed through the House of Commons. It was passed through third reading on June 16, 2017, and is presently sitting before the Senate at second reading and is being debated as we are this year, in fact. If we come to some of the language from the government's background or in the press release, I think it's important to read this into the record because it highlights some of the background for why I will be bringing forth some amendments for discussion at committee stage. The backgrounder for the Workmen's Compensation Act Amendment Act states as following. It states, currently the Workers' Compensation Act provides any worker with workers' compensation. The term worker is actually defined under the Act. I encourage people to see how it's defined. Any worker with workers' compensation for a mental disorder, again, that's described in terms of the American Psychiatric Association's Diagnostic and Statistics Manual. Compensation for a mental disorder caused by their work, including PTSD, it says. There are two recognized situations for work-related mental disorders. This is critical, Honourable Speaker. There's two recognized situations of work-related mental disorders. One is a reaction to one or more traumatic events at work, or two, one that is primarily caused by significant work-related stressors, such as bullying and harassment. In both of these situations, I'll cite some examples of why I think that we need to be a little more inclusive in this legislation. It's quite clear to me that this legislation is targeting professions that you might get a lot of one, that is a reaction to one or more singular or multiple traumatic events, but less so to number two, even though it still would apply number two, which is the primarily caused by significant work-related stressors such as bullying or harassment. It would apply to those same professions. It continues in the background. It says, in order for the claim to be accepted, medical and/or scientific evidence must be provided to establish that the condition arose out of their employment, in addition to a diagnosis by a psychiatrist or a psychologist. That's in the current one. That puts the onus of proof on the sufferer of the mental disorder. And that, in and of itself, Honourable Speaker, can be profoundly troubling and creates great mental anguish to the person who's actually been exposed to the issue causing them a mental disorder. And in some cases, they might choose not to pursue it because of having to relive the experience. In other cases, they might try to pursue it to their frustration and adding to the compounding of their mental disorder because of the fact they feel the system is not listening to them. And indeed, I have examples of that too. A presumptive clause, or a presumption under the Act, provides that if a worker has been employed in certain occupations, again, coming back, those are a correction officer, emergency medical assistant, firefighter, police officer, sheriff, or others as prescribed by regulation. And if that worker develops a disease or disorder that is recognized as being associated with that occupation, then the condition is presumed to have been due to the nature of their work, unless the contrary is proved. So it switches the onus of burden. You still have to go through the process of meeting with doctors, qualified psychologists and psychiatrists, and having this condition professionally assessed and determined to be a result of a certain cause or causes or systemic problems in the work environment. But now, though, with a presumptive condition, there is no longer a need to prove that a claimant's disease or disorder is work-related. The proposed legislative amendments, it further says, will establish a new mental disorder presumption when the condition is a reaction to traumatic events at work. A secondary thing, I'll very briefly touch upon another. It's a very welcome addition, and frankly, I think it's an oversight to previous additions to this Act. It's not going to be the dominant discussion within this House, but it's profoundly important, particularly for some of my friends who actually work on the Esquimalt DND firefighters. The amendments will now expand in this Act will expand existing cancer presumptions to federal firefighters. In our area, it's very specific to DND, and the DND firefighters come in to help out in Esquimalt, Victoria, and elsewhere when there's large calls, and they're very active and, in fact, exposed to the same chemicals, particularly if they're working side by side with Victoria or Esquimalt or View Royal or Colwood firefighters. And this new legislation is going to bring existing cancer presumptions to these federal firefighters employed on military bases, so that federal firefighters currently who qualify for the heart disease and injury presumptions, while they do already qualify for that, they're not qualified for the cancer presumption. So this is a very good addition, because at present it's limited to local government firefighters under the provision. This Act, again, is a direct response, in my view, to, as was the previous private member's bill, a Union of BC Municipalities call for an amendment to the Workmen Compensation the Workmen Compensation Act to include a presumptive clause for first responders. So in the 2015 UBCM, the Union of BC Municipalities, which represents the local governments across British Columbia, specifically passed a resolution, and I thank the good municipality of Central Saanich, embedded within the provincial riding of Saanich North and the Islands, where my friend, who's not here right now, is from, my friend to my right here. This is the motion that they put that was passed in UBCM. It says this: whereas first responders will include 911 operators, again, the motion specifically refers to 911 operators. They're talking there both about call receivers as well as call dispatchers. It says here paramedics, firefighters, peace officers, police officers, sheriffs and correction officers, and many first responders have been affected by mental health injury/disorder, thus replacing PTSD with mental health injury, : it says, and whereas there is a need to change the Workers' Compensation Act under Section 5.1 to add a presumptive clause, as it is possible that within first responders' duties they will encounter horrific acts and develop a mental health injury. Therefore, be it resolved that a 2-month maximum deadline be implemented when making a decision at any decision point of the claim regarding a mental health injury claim, based on one psychologist and/or psychiatrist report. And be it further resolved that upon receipt of a mental health injury claim, the worker should receive immediate financial benefits and treatment, with the understanding and agreement of the worker, their specialist, and WorkSafe BC, that if it is proven that the injury was not as a result of their duties of employment, there will be a repayment plan for the costs. And be it further resolved that when the worker is, and I quote, fit to return to work or retraining, end quote, there will be a follow-up plan to be agreed upon by WorkSafe BC, the specialist, and the worker. And be it resolved that under Policy 97.34, those of you who've been to UBCMs will realize that there are many, many policies, and I challenge people to find this. No, they will, but there's a lot of them to go through. A conflict of medical opinion, the probable difference of opinion shall be discussed with the physicians referred to the treating physician or specialists involved, and if it is concluded that there is doubt on any issue, the board must follow the mandate of Section 99 of the Workers' Compensation Act and resolve that issue in a manner that favours the worker. And be it resolved that the province of British Columbia adds new legislative language to Section 5.1 of the Workers' Compensation Act, adding a presumptive clause for mental health injuries as set forth in the resolution to ensure the well-being of all first responders who have sustained a mental health injury. Coming back again to that specific motion passed at the UBCM in 2015, the first one that was included were 911 operators. So continuing back to the motion, it says, a motion duly moved and seconded to amend the resolution by replacing the 5 enactment clauses with 1 enactment clause, reading, quote, therefore be it resolved that the provincial government work with WorkSafe BC, first responders and other stakeholders to review and amend the Workmen Compensation Act with the goal of supporting the well-being of first responders who have sustained a mental health injury. Was not, so that's just getting complicated. It says it was not endorsed there, but that was a bunch of sub-motions within it. Nevertheless, we have that coming out of UBCM. It's good to see that the government has responded to that. But what's more important as well here, of course, is that we have to ask the question, why is it that BC took so long to actually deal with this issue. We are really, other than Quebec, one of the large major provinces to move forward with it. We have two shining examples in Canada, those being the provinces of Alberta and Saskatchewan, we'll come back to that in a second, who actually recognize, coming earlier to the government's the government's backgrounder, recognize that there's two situations of work-related mental disorders, a reaction to one or more traumatic events at work, and one primarily caused by significant work-related stressors such as bullying or harassment. Recognizing that, the provinces in Alberta and Saskatchewan now cover all psychological injuries defined by the Diagnostic and Statistical Manual, and they do so for all professions. And why is that important, Honourable Speaker? Most other provinces, Manitoba, Ontario, New Brunswick, Nova Scotia, Yukon, Prince Edward Island, for example, largely cover PTSD, although in Ontario there's some new legislation coming forward adding nurses as well. But why is it that we have more progressive provinces actually going further? Let's go directly to the Workmen's Compensation Board fact sheets from both Alberta and Saskatchewan. Alberta has two such fact sheets that are relevant here, the Traumatic Psychological Injury fact sheet and the Post-Traumatic Stress Disorder fact sheet. That's the PTSD fact sheet. Let's focus on what it says is the difference. Effective December 2012, Alberta actually covered firefighters with PTSD presumptive clauses, as well as emergency medical technicians, police officers appointed under provincial regulation, and also effective April the 1st, they've added correctional officers and emergency dispatchers too. And if we look at the traumatic psychological injury within Alberta, we see that that extends to effective 2018. It says all workers covered under the Workers' Compensation Act who have been A, exposed to a traumatic event during the course of employment, that could lead to PTSD, and B, diagnosed with a psychological injury by a physician or psychologist, are eligible for presumptive coverage through WCB Alberta, unless the contrary is proven. Honourable Speaker, this in Alberta applies to every worker in Alberta, whether you be a teacher, whether you be a nurse, whether you be an emergency dispatcher, whether you happen to be a social worker. And let's imagine some cases. We see this legislation here as a direct response to very effective lobbying by police, by firefighters, and we thank them for their lobbying. But we must, as legislators, we must not stop there and say that those who have lobbied are the only ones who have the issue. I would argue that they are very efficient and effective lobbyers. And they are lobbying not only on behalf of their profession, but on broader society as a whole. I have a cousin who's a firefighter. I understand what it's like I don't understand to be there. I want to understand what it's like to witness someone come home after they've scraped someone off the road following a significant car injury. Over the years, I've done some expert witnessing myself in the forensic meteorology, and I've seen horrific pictures, but I've only seen them as pictures. I cannot imagine what people, firefighters or paramedics, first responders, would actually see when they go there and having to scrape this off. Or in Oak Bay, can you imagine what those police who had to show up at the young home of the two young children who were murdered by their father, can you imagine what they went through? I understand this. But let's also think about that social worker who has to go into a home and goes into a home and sees systemic child abuse happening in a home. And suppose that social worker who's seeing systemic child abuse tries to get their superior to take steps to deal with it, and they're not. That can be a problem. That can lead to profound down the road problems. What about teachers? What about a teacher who's standing up and teaching their class for years, and then all of a sudden they have a child in the class that's clearly coming from a troubled home? The teacher has a duty to respond and report, and teachers are professionals, they will and do all the time. But there are times, and I'm dealing with some in my own constituency, There are times when nobody listens. When nobody listens, the administration is not supportive. When the system starts to protect itself, yet the teacher is the one who has to deal with this on the front line, and this can lead to down the road and ongoing systemic issues with respect to depression and anxiety. Again, I come to a case that's going on in my constituency right now, a very serious case that falls right in that definition. Where's WCB for them? Where's WCB for the person who now has to prove that their illness comes from the work environment? And when the system is trying to protect itself, Honourable Speaker, when the system is trying to protect itself, that can be very hard, because your superiors are not going to be writers of letters saying, yes, we understand this person. Honourable Speaker, this is why it's critical to include thee. What about nurses, Honourable Speaker? What about nurses who are frontline responders in many cases? Why are they not included in this? They would be in Alberta. I'll come to Saskatchewan in a second. They would be in Alberta. What about heavy truck drivers working on site where a major accident, a construction accident occurs? It can have devastating effects on the workers on that construction site. It can have devastating psychological effects, which can be, through proper medical intervention, assessed and attributed to that accident, but they're not covered under workmen's compensation. Yet in Alberta, they would be, Honourable Speaker. What about somebody working in an office in downtown Kelowna in an abusive work environment, but that person happens to be a single mother or a single father, and they're earning just enough to make ends meet because at home they have an autistic child, and they have no family in town, and they've got this one job, and they can't quit this job, because if they quit this job, they'll be on welfare. Yet they're in a systemically abusive environment that leads to anxiety and depression and anxiety disorders, or other such mental illness. And they go to their psychiatrists and they go to their psychologists, and it's very clear that it comes from the recommendations there. But again, they have to prove this. And as somebody going forward to workmen's compensation has to prove it, they have to relive everything. They have to relive all of those experiences as they try to prove that their illness is a direct consequence of their work. Progressive jurisdictions like Alberta, and let's go to Saskatchewan, recognize this. And they recognize that it doesn't stop the due medical process from still occurring. It doesn't stop workmen's compensation from challenging an assessment, but it does provide a presumptive clause that would ensure that workers actually don't have to relive every incident in order to prove it before workmen's compensation. Let's go to Saskatchewan, another progressive jurisdiction. Now, Saskatchewan has a two-page fact sheet, and if you go to page 2 on this fact sheet entitled Psychological Injuries, it says this: does the psychological injury presumptive clause guarantee that my WCB claim will be accepted? It says this: the WCB, where that's Workmen's Compensation Board, will gather information to determine if you've been exposed to a traumatic event or series of traumatic events that occurred during work, and if it is acceptable under the presumption. So they're still able to gather evidence. They're still able to make an assessment and a potential challenge if they don't believe this was a result. But this presumptive language is there. The presumptive language is in the legislation that would protect the worker from actually having to relive that experience. This doesn't cost a lot, Honourable Speaker. This doesn't cost a lot at all. The projected costs if I could just find my assessment of the projected costs here. The projected costs are, let me find them. Well, look at that. I can't find oh, they must be here. Yes, I found my projected costs. Well, I'm quite troubled by that, Honourable Speaker. I seem not to be able to find my projected costs. Nevertheless, I'll continue. Just have one last search. Look at that. Now, I suspect that government will step forward and suggest that in the case of some of them, I found the projected cost, Honourable Speaker. WorkSafe BC undertook these projections, and they suggested that the total cost for the presumption of the group of workers considered here would be $6.3 million a year across all of BC. Now, WorkSafe, it's not clear whether that's going to have any effect on actual premiums, because WorkSafe BC doesn't actually spend all the money they're bringing in at this stage, so that could just be zero cost, Honourable Speaker. And of course, the cost, any increases in WCB would actually go down to the local government and municipal level, and the impacts depend on the size or the payroll. For example, Terrace. Terrace is a small municipality, and estimated that this presumptive clause for the included all included classes would have cost about $4,000 a year. That's $4,000 for the entire city of Terrace. I think it's worth it, Honourable Speaker. Kelowna, it's a medium-sized city. Kelowna, $32,000 a year to cover all of these presumptive clauses. $32,000 a year alone. It's not a lot, Honourable Speaker. And Surrey would be $86,000 a year. Large metropolis, a city there. So we're not talking about a lot of money in these, but however, it's critical to also think not only about the upfront cost, Honourable Speaker, but also the costs avoided. Costs avoided. Again, not only with the specific case of the people who are eligible workers, but also with broader society. If you can avoid long-term costs of healthcare, long-term costs associated with frustration, compounding of mental disorders because of a lack of ability, a feeling out of control from an inability to actually advocate for yourself, and no one's listening to the job environment, you can save money in the long term. And not only that, Honourable Speaker, with the presumptive clause, it gives WCB a little bit of power. A little bit of power that's absolutely critical, particularly in larger institutions. And why that is critical, Honourable Speaker, is if we come back earlier to the two classes that are covered now in the present Workmen's Compensation Act, the two classes of coverage. One is the I really should number these better, Honourable Speaker. I do apologize. I will find this, or I won't. The two classes, I want to get them exactly right for Hansard, so I'm not misquoting. Here we go. The two classes, 2, 3, 1. 2, 3. Honourable Speaker, I seem to be filibustering my own time here. I don't mean to do that. Here it is. The first one is, of course, a reaction to one or more traumatic events at work. That's the first class. And the second is one primarily caused by significant work-related stressors such as bullying or harassment. Now, I'm the designated speaker, Honourable Speaker. So coming back to number two. Number two is critical. One primarily caused by significant work-related stressors such as bullying or harassment. Now, why is that important? In larger institutions, we all know people who work in larger institutions, whether they be government, whether they be hospital boards, universities, whether they be school districts, whether they be colleges, whether they be large places of work. We all know and have many a story to tell about workplace bullying and harassment that goes on. But in these institutions, very often, people feel that nobody's listening. And the reason why they feel that nobody's listening is because you have to prove a mental health issue would be a direct consequence of your work. With the presumptive clause, the onus then comes on the employer rather than to cover something up, but to actually deal with the systemic problem, because otherwise their Workmen's Compensation Board fees are going to go up. There's an incentive to actually deal with workplace bullying if you actually include a presumptive clause for all types of workers covered under the Act. I find it odd, Honourable Speaker, that I'm the leader of the BC Green Party and I'm arguing better labour policy to the NDP. This is a very odd situation, Honourable Speaker. And I can only hope that they see the light and recognize what Alberta and Saskatchewan did, that this is about incentivizing safe work environments. Last year, or it's 2 years ago now, I stood in this House and introduced a bill that would require university campuses to add sexualized violence policies, to insist that they have them, because the culture on campuses, from small to big, was one of, it's not our problem. It's one of not dealing with the problem, because if these universities and colleges and smaller institutions want to be perceived as safe places for students, so if there's an issue of sexualized violence, it's kept under the table, it's quiet, and policies aren't really implemented. The Premier at the time stood up and agreed that this was an important issue, and we saw that legislation passed. And it's led to good policy being put in many, but not all institutions. All institutions have it, but not all have as good policy, as we'll hear about in the weeks and months coming ahead. But nevertheless, it required institutions to recognize that a problem exists. The ultimate penalty that they would have would be this stick of advanced education funding, which could ensure that they actually dealt with it. But in the case of workmen's compensation, Honourable Speaker, they too have a stick. If you are in an unhealthy work environment, one that's conducive to bullying and harassment, and we all know examples of this going on, if your management does not step in to deal with it, and workers start to go on leave, and following the presumptive clause, that reason for leave is actually pinned on the work environment, without having to relive it and prove it, then there's an incentive to actually stop, to intervene, because your premiums will go up. And you can bet when it starts to affect your bottom line, it will make a difference. So I will not accept arguments from government. I will not accept arguments from government that somehow this is going to cost so much to everyone. Because in fact, it should not cost anything. Because if institutions step up to deal with the problem, they should actually not cause it to rise. It's there to protect workers, it's there to save the healthcare system, and it's there to ensure that institutions step in to deal with systemic bullying and harassment that too often is ignored in larger institutions across our province. In Alberta and Saskatchewan, again, one government, an NDP government, another government, well, Saskatchewan party, let's call it the Conservative government, across the spectrum. This isn't a partisan issue. It's a recognition of good public policy that employers need to be responsible. And not everybody has the ability to quit a job and go somewhere else. Honourable Speaker, I want to come back. You know, I've talked about nurses, I've talked about teachers, I've talked about construction workers, I've talked about 911 dispatchers, and I've talked about office workers, but there's many other professions. But I want to focus right now a little bit on 9/11 operators. And I'm going to focus that on a story, because I think a story says it all. I cannot accept that government has any rationale not to have 9/11 officers named in this act. Named in this act. I cannot accept that. Because we know, according to the Canadian Journal of Psychiatry, that public safety personnel, including paramedics, police, firefighters, dispatchers, and correction officers, are 4 times more likely than the general population to screen positive for clinically significant symptoms consistent with one or more of the mental disorders that we've been talking about. And if we need the research on that for the 9/11 dispatchers, I have some right here, Honourable Speaker. It's not a prop, it's just white paper. I have in my hands a document that I won't read in its entirety into the record, but it's a thesis that was from the University of Fraser Valley, fine institution from down in the valley. Thank you to the member from Chilliwack, Kent. He recognizes that it is a very fine institution. It's a Master's of Arts in Criminal Justice. Actually, Honourable Speaker, I suspect our Speaker might be aware of this particular article because it was from his former department there in the University of Fraser Valley. And its title is Prevalence of PTSD Prevalence of PTSD symptoms in Canadian 9/11 operators. We have an entire study here, and it's BC focused, that points out the obvious issues with respect to mental illness, particularly PTSD and others, that associated with emergency dispatchers and call receivers. And let me finish, Honourable Speaker, with a story that I'd like to read into the record, because this is the story that I'll read, and I've been given permission by both the person who got it to read it. So she is, or he has given me that permission. But what I've done here is I don't want to give out any names, and I've removed any identifying markers in this so that it's a story that I can vouch to be true from a very real person in a very real part of British Columbia that had very profound consequences. Now, this person now has told me about how she or he has consulted at least 6 dispatchers from not committing suicide. And the stories, Honourable Speaker, the stories I heard, not only from nurses, not only from teachers, but from emergency dispatchers. One of these stories was a caller who received a 911 call from a passenger who was in a car in a motor vehicle accident, reporting that. And that passenger sees a head rolling by, a dismembered head. Can you imagine that? And the caller's on the phone dealing with this passenger, as this passenger is in hysterics. That had a profound effect, because that person is the first responder. That person is the first responder. And this story, Honourable Speaker, I hope government listens to this story and reflects upon it prior to us debating this in committee stage. The story goes like this. Mr. X was his name. He lived on the 2nd floor of a 4-story apartment building about a block or so away from YYY. I don't remember the street name anymore, although I do remember that it has exterior stairs that go up to each floor, because ERT used them. That's emergency response team. And I remember hearing them stomp up them, clanging on the metal stairs outside his open window. I received a 911 call, where all I heard was a muffled sound of pain, and then a hang-up. When I called back, a male with a thick accent answered, and he didn't want to talk to me, but clearly he was crying and/or in pain. I worked hard to establish a conversation with him and find out what was going on. Eventually, he trusted me and told me that he had already committed harikari by stabbing himself in the stomach with a large knife and was currently sitting on his bed with his entrails hanging out. He tried to kill himself and now was really scared and didn't want to die alone. Not that he didn't want to die, he just didn't want to die alone. I created the Priority 1 call and advised the chief dispatcher, who then continued to listen for a bit, off and on, through the call. His apartment door was locked, and so this became a barricaded man with a weapon call, and ERT was called out. He refused to talk to the officer at the window, but when talking to me, he would go back and forth between wanting to live and wanting to die. I convinced him that I cared, and that if he wanted to live when he needed to come out, then he needed to come outside so the officers and the waiting ambulance could help him to hospital for help, could help get him to hospital for help. He believed me and was going to come out. Then he heard the ERT officer ask for a member at the parking lot to bring him the spud gun. This set Mr. X off on a tangent of terror. He didn't want to be shot. He wanted to live, but he refused to talk to the ERT member at the window. At this time, he was still bleeding and the knife was still in his stomach. He kept telling me he was going to just pull out the knife and let himself bleed to death if the cop at the window wouldn't leave. On my end, I had my team manager telling me to hang up, the chief dispatcher telling me to hang up, and common sense told me to hang up, but I couldn't. I couldn't be the person who caused this man's death. I told Mr. X that he needed to talk to the cop at the window, that they were there to help him. He went really quiet and then wouldn't answer me when I asked him if he was still there. So I clicked on my mute button so he wouldn't believe that I had hung up, and then just listened. All this time I was typing as well, letting the officers know what was happening, and the dispatcher was doing the same with their stuff. I saw in the call the request for the spud gun, and that there wasn't one on scene, but it was on the way. They were waiting and still trying to establish contact with Mr. X, trying to strike up a rapport with him. He kept crying and denying them, accusing them of trying to kill him and asking them to let him talk to me. Remember, Honourable Speaker, at this juncture, she's on the phone with the mute button, unable to speak. He blamed them for making me hang up and told them that he was going to die because of it. Car number, I won't say what car number it was there as well, and he asked the chief dispatcher where the call taker was. He was advised that I was still on the line but was being silent on mute. They were also still waiting for a negotiator to arrive. He was at least another 30 minutes away at this point. So, Honourable Speaker, you have to got the picture now. Man, knife in his stomach, entrails hanging out. We now, because he has a knife, we have an ERT team. We now have to wait 30 minutes for the ERT team to come because he's an armed person in there. And who's on the phone? This one emergency dispatcher. I continue with the story. I knew that Mr. X wasn't going to live that long. If he was bleeding badly from his belly, then we didn't have much time. I don't know who it was, but I heard through my headset an officer yell at the dispatcher to tell me to hang the F ... up. I'll let the Hansard fill that in if they so choose to. I don't think it's parliamentary to do so, but I'm reading directly here from this thing. I do know, though, that it wasn't car number, because it wasn't his voice. I know his voice. I felt the horror, the terror of impending death, the helplessness of having my hands tied, incapable of doing anything for this man, and I could not hang up. I was frozen. I was convinced that if I hung up, he was going to die. I also believed at that point that if I said anything more, that I would be in big trouble. So I sat there for about 10 minutes listening, vibrating physically and tears running down my face. I saw in the call that the spud gun had arrived, and I could hear the dispatcher's comments that an ERT member was trying to get a clear shot from the window. They were going to shoot him. Now, common sense tells me that this won't kill the average man. It's a spud gun, Honourable Speaker. But this man already had his guts hanging out of his belly, had already lost a lot of blood, and was already traumatized by all this. I'm quoting again, Sue, F ... exclamation mark, no need to fill it in, is in the text here. This is a direct quote that was given to a psychiatrist as terms of what happened. I looked over at the dispatcher who was looking at me. She very slowly nodded her head at me and my tears. She knew that I could change this around if I was allowed to try. I think she was telling me to go ahead and do it anyways. At this point, I created the call almost 40 minutes ago. That's 40 minutes this woman, this call dispatcher, this call receiver, sat through this traumatic event. And there wasn't much time left, any at all. I made the decision and typed into the call that I had established a trust with the man and that I was going to reestablish contact with him now. At this point, Mr. X was yelling at the cops to all go away and leave him alone to die, that he was going to die, and it was all their fault. I started saying his name over and over until he stopped yelling and he heard me. I started talking with him again, got him to listen to what I was saying and trust me again. I talked him into coming outside with his hands up and letting the officers get him the help he needed, and he did. I typed this into the call, and the chief dispatcher came back on the line. She coordinated it with the ERT at the door while I talked to Mr. X. He was scared, but he did it. He unlocked the door, then we counted to 3, and he opened it and stepped outside. I heard the officers take him down and him screaming all the way through it. They got him into the ambulance and off to hospital. I then hung up and just about collapsed. I had to leave the room. But on my way out, I heard the chief dispatcher talking on the phone with someone that I can assume was car number. She was defending me, telling that person, quote, well, she did so it doesn't matter, ... Well, she did, ... Well, she did, end quote. As I walked past her out of the room. When I came back into the room about 20 minutes later, car number was there talking to my team manager. He was visibly angry and told me in a very stern voice, I don't ever want to hear of you doing that again. But then he stuck his hand out to shake mine and said, good job, you should take negotiator training. What? I was left with the feeling of not knowing whether I was in trouble or being congratulated, whether I was coming or going. I never found out whether or not Mr. X lived, and I tried to find out a few months later. The officers didn't know, and victim services was unable to confirm he survived. Equals, he did not. I feel the guilt and responsibility for this young man's death. It is a moral injury that I will likely never recover from. The kicker here, my employer and ZZZ inspectors wrote me a, quote, "attaboy for a job well done." They congratulated me for successfully causing a human being's death. I didn't sign up for that. I'm not a police officer and was never prepared for this possibility. Now, Honourable Speaker, that is just one of many, many such stories that I have received over the last few weeks. And I've got stories like this from nurses, and I've got stories like this from teachers, and I've got stories like this from a diverse array of professions. But one thing I cannot accept is that when in opposition, this government delivered a private member's bill that included specifically 9/11 dispatchers and callers, and now, when in government, they leave out 9/11 dispatchers and call receivers. They are first responders, Honourable Speaker. In many cases, they are the first responder and the last person to hear someone alive. The last person to be the first responder. The last person to be the first responder while someone's alive. They listen to cases like this. And there are many, many other examples. And while I understand that some emergency dispatchers are paramedics and so would be covered, and some are police officers and so would be covered, but not all, and many are just civilians and need to be covered under this legislation, Honourable Speaker. So over the course of the estimates, I have a series of amendments to bring forward, one of which I hope is passed, which I'm putting in, is on the order papers, will to extend this legislation across other jurisdictions, all other workers as defined in the Act, just like they've done in Alberta, just like they've done in Saskatchewan, to actually protect workers from abusive work environments, as well as to provide presumptive clauses not only for systemic harassment and bullying, but also for traumatic events. So that's the first, and I hope government sees the wisdom in that. And as people look at the order paper amendment that I'll bring in at committee stage, you'll note that I recognize that government may have done some back work, and so royal assent with the amendment would remain the same now as proposed here, but would be extended a year so that we'd give government a time to have royal assent for all other workers not already defined in the amendment here. That's the first one, Honourable Speaker. And I have some subsequent ones hoping it won't be necessary to raise under the assumption that government recognizes that we can do better. We can do better, and at least we gotta do as well as Alberta and Saskatchewan. We're a Western province. We value our workplace. And for the first time in a very long time, we have a progressive democratic government here. A government that actually brought in private members' bills to do this. And in my view, are timidly responding in a populist fashion only to those who've directly lobbied without thinking about the broader consequences and the broader opportunity that is sitting itself before us now. So I thank you, Honourable Speaker, for your attention, and I look forward to debating this further at committee stage.